Good morning, Ms. Page.
Good morning, CJ.
How are you this morning?
I'm very well, thank you, CJ, for asking.
Yes. Thank you for availing yourself and making yourself available for consideration for appointment as a judge of the Free State Division of the High Court.
Thank you, CJ. It's an honor and a privilege for me to be here.
Yes. I will ask you to raise your voice a little bit.
Sure. Thank you for that.
Yes, because I think you have a soft voice.
I will speak up. Thank you, CJ.
Yes.
Is that better?
Yes. I'm going to ask you certain questions, and after that I will allow the acting judge president of the Free State Division to ask you questions, and thereafter I will allow the representative of the Premier of the Free State, MEC Kabate, to ask you questions, and after that it will be the commissioners who will get a chance then to ask you questions.
Thank you, CJ.
Okay, right. And I see that in terms of your qualifications, you hold a BA Law as well as an LLB. The BA Law degree you obtained from the University of the Western Cape, just as is the case with your LLB, is that correct?
That's correct. Thank you, CJ.
And you obtained your BA in 1991 and your LLB in 1992.
I think both is in 1992, CJ. I just want to have a look at my certificates that I have present here with me. Mm-hmm. I remember that when I completed my BA Law, I still had one semester course, which I then completed in the first semester of 1992, and I then, oh yes, it is correct. In 1991 is the BA Law degree, and then the LLB in 1992. That's absolutely correct. Thank you, CJ.
Would 1991 be the year in which the degree was conferred, but you had completed the studies for BA Law in 1990?
That's correct. There was one, I think, one semester course at some stage that I had to carry over. So I obtained the BA Law degree in 1991.
So you completed your studies in 1991 because there was one course left, and then the degree was conferred
CJ, it's so long ago, but
year.
let me just rectify from my memory. I completed the BA Law degree within the 3 years and then obtained it.
But when was the last year?
I think I carried over one of the courses when I started with my first year LLB, and that is why I obtained my LLB in 1992, because I did carry one of the BA Law subjects with my first year LLB, because the LLB is 2 years, which I obtained in 1992.
Okay,
Does that make sense, CJ?
I'm not sure if I understand.
When
did you complete all the requirements for the degree of BA Law? Which year did you complete the last requirements of your BA Law?
In 1991.
Okay, and the degree of BA Law was conferred upon you in 1991 as well?
That's correct, CJ.
Was that as a result of the fact that you were supposed to complete your studies for BA Law in 1990, but there was one course left which you had to do in 1991?
CJ, I haven't, it's so long ago, let me just,
Sorry?
I'm also confused now. I started my BA law degree in 1987, so it's a 3-year degree. 86, 88, 80, 90.
87 or 86?
87 I started, and then 88 and 1989 I had to complete my BA law degree.
If it's a 3-year degree and you started in 1987, 3 years would have ended in 1989.
1990.
No, 87, 88, 89. That's 3 years.
That's correct.
Yes, so you should have completed your BA law in 1989. Is that correct?
Yes, CJ, it is correct. It should be. I started in 87. 87, 88, and 89 I had to complete. I think there must have been one course that I carried over because I obtained my LLB degree in 1992, which is a 2-year degree.
Leave out the LLB so far. Just let's finish with the PA. When did you complete? When did you meet all the requirements for your PA law? When was the last requirement that you met?
In 1990, I finished, and I only received the degree in 1991.
You complied with the last requirement or requirements for your BA law in 1990.
That's correct, CJ. I think that is correct. I did not really put my mind around this, but I think that was the case, yes, because the graduation only followed the next year in 1991, as per my certificate.
Okay. Does that mean your BA law took 5 years? Or 4 years? 4 years. 4 years.
That could be correct. I carried over one subject, which I did with my LLB in 1991, first year, LLB year.
Okay, so your LLB took 2 years.
That's correct.
But your BA took longer than 3 years.
Yes, I carried one subject over that took longer, which I completed together with my first year LLB in 1991, and then completed in 1992.
Yes, okay, no, that's all right. And then you served your articles after that, is that correct?
No, CJ, I started my career initially
as a legal advisor.
That's correct.
Yes, that was 1992 to 1994 in the city of Cape Town.
That's correct.
Yes,
CJ?
And you were then appointed as a public prosecutor in the magistrate court in Cape Town from 94 to 95.
That's correct,
And then you
CJ.
became a state advocate from 95 to 97.
That's correct, CJ.
And then that is January 97. From February 97, you started articles.
Correct,
With
CJ.
a law firm in Cape Town, is that right?
That's correct, CJ.
And you finished your articles in July 1998 or 1999? 1999, I think.
I was admitted as an attorney on 20 April 2001. I was admitted as an attorney on the 20th of April 2001.
Yeah, but when did you finish your articles?
My articles, if you will note from my application form, there was a time I registered the first article clerkship with a firm, and then for a short.
No, Ms. Page, don't worry about when you registered them. I just want to know when you finished them.
CJ, if I was admitted as an attorney in 2001, the 2-year period would have lapsed already. I think I had a leeway still to complete my examinations. So I remained an article clerk until my appointment as an admitted attorney.
So when did you say you got admitted as an attorney?
On the 20th of April 2001.
Yes. And did you practice as an attorney after that?
That's correct. After my admission as an attorney, I remained in private practice until the 6th of May 2002 when I was appointed to the district court bench.
I see that you were a magistrate for quite some time. Is that correct? From
That's correct.
May 2002 to February 2019.
That's correct, CJ.
Was that in Cape Town?
That's correct, CJ. Goodwood Magistrates Court.
And that's about what?
17
is that about
years?
17 years?
Correct, CJ.
Okay. Did you do both civil work and criminal work as a magistrate?
Yes, I did. Both criminal and civil work in the district court bench.
What types of civil cases did you do?
Since 2000 and I think late 2003 up to very late in my reign as a magistrate, I did mostly civil work. The types of work I did was motion court, unopposed motions, motion court, trial court, ranging on all areas of the law, delict, contractual matters, all kinds of civil work matters.
Share with the Commission that information because it's important to see the civil experience that you have in terms of what kind of branches of law have you been involved in that will help the Commission have an idea of what experience you have had in civil matters at district court level. At
district court level, as I've indicated, motion court, unopposed matters that ranges on covers many areas. Summary judgment, debt reviews, default judgment, those matters that are normally on the unopposed roll, on the opposed roll as well. Various applications, urgent applications, ex parte applications, opposed motion applications, trial court, many contractual matters, delictual matters, claims. I remember the specific one based on delict was a claim by a plaintiff, an elderly lady, who instituted proceedings against the nearby shopping mall. She had climbed up the stairs and there was no...
No, at this stage, don't talk about the facts. I just want the branches of law. Company law, liquidations. Did you have liquidations? That kind of thing?
Yes, not company law much. Insolvencies. As far as company law is concerned, we obviously on the motion court would deal with liquidations of companies, liquidation applications, etc. But all fields that I can think of that I've dealt with on the High Court level, aside from probably a few which are only High Court related matters, it was wide-ranging. All civil areas of the law. I have relatively many years of experience in adjudicating civil matters in the district court. If I might also just add, I was sitting in the regional court, civil court at the time, which only heard civil matters in Cape Town, where some of the matters were transferred from the High Court to the Civil Court, in the regional court to allay the pressure of the High Court for matters that they were unable to hear as a result of maybe heavy caseloads. So those civil matters were also covering many spheres, commercial, delictual, opposed applications, liquidations, contractual matters, some commercial matters dealing with commercial documents, negotiable instruments, hearing interlocutory.
No, that's fine.
Thank you, CJ.
If you kept your judgments in the district court, written judgments,
yes.
About how many written judgments would you say you?
CJ, I actually kept all my judgments on a flash drive, but somehow I lost it, and there's no way to recover it instead of going back to court and receive it. But it must be in the 17 years. It must be probably 100 or more written. I always furnished written judgments in most of my civil trial matters, even opposed matters, as I've done now while I was sitting in the High Court. I've obtained much exposure in the civil courts, in lower courts, which has laid a very good foundation for me. So when I entered the High Court here as an acting judge, I felt comfortable. When I walked into civil court, I was able to identify matters before me with ease, because the rules of procedure are much the same as in relation to civil applications, opposed matters, and so forth.
No, Ms. Page. My question was about how many
judgments
you have written. Yeah.
It could, if I have to guess, it's 17 years, CJ.
Yes.
There are many. If it's
that's fine. How long have you acted in the High Court?
I've acted in the High Court for 2 stints, and I counted the weeks. It could be about 22 weeks if I add the additional week that I have had to come back to finish a matter at Bethlehem Criminal Court.
Yes. And you said, did you sit both in civil matters, motion court and criminal court as an acting judge?
Yes, I have, CJ.
Yes. And how did you find motion court in the High Court?
If you're referring to motion court, unopposed motion court.
All motion court.
Sorry, CJ.
All motion court.
Unopposed?
Unopposed and opposed.
The unopposed role, I enjoy doing that because I've done that on district court level. We would deal with about 70 matters a day in the district court, regional court, sometimes more than that or less than that. So I enjoyed doing the motion court. It is a lot of work, but with preparation and before you walk into court, I was able to easily just manage to do it. I finished the role probably 1 o'clock. I had about 90 unopposed motion matters, and I was able to deal with all the applications before me. Since I prepared the court roll, I was able to identify the different areas, the different applications with quite a lot of ease and comfortability. I'm quite comfortable to do both opposed and unopposed matters. The opposed matters would be set down maybe 2 or 1 per day, and I would prepare the file, read the papers, prepare, know the law beforehand, walk into court and be able to hear arguments from counsel, and it was quite easy for me. I was very comfortable, I must say, in both in unopposed and opposed motion court.
And how many judgments have you written judgments do you have in the High Court?
CJ, I have not...
More or less, I don't necessarily
I can give you more or less.
exact-
It
the
must be
exact number.
between 15 to 20 written
Yes.
judgments.
Yes,
I try to give written judgments in all my matters.
yes,
Because I was obviously acting and I needed to deal with the judgment in that fashion. I did not really give any extempore judgments, apart from obviously when there was a settlement, and I would make it an order of court
yes.
by agreement between the
And
parties.
did you sit in full bench appeals while you were acting?
Yes, CJ, my first case was a full bench appeal when I started on my first day, and I was
Yes.
requested by the two senior judges to write the judgment.
Yeah.
Something I think is probably not common, but I took the challenge and I agreed to do so. It required of me, obviously, to delve into areas of the law and spheres of the law that I might not have had so much exposure of, but I quite enjoyed writing this judgment. It required me, if I may still continue, CJ, or have I answered?
No, just answer the question only.
Thank you.
Now, what is the test for the granting of an interim interdict?
An interim interdict,
Or what are the requirements for an interim?
there must be a clear right for the applicant, and no other remedy available to the applicant. There is a third one. If I can just want to, if you will allow me, CJ, I just want to have a look at a note.
Did you write it down?
I know I've done one of those matters. There must be a clear right and infringement of that right, and no other remedy available to the applicant.
Are those all the requirements? Or I heard you mention the possibility of a third one.
Those are the elements of the interdict, CJ.
Okay, and and the requirements for a final interdict?
On the return date, obviously, you would have to establish that if the matter was then opposed, you'd have to establish on the papers whether the applicant has in fact satisfied those three requirements, the same requirements, and then you will grant the final order.
If it's unopposed?
If it's unopposed, you must make sure that the rule 9 has been served on the opposing side, if it was ex parte, or if the parties were present when you heard the application and the rule 9 was granted, you'd have to, if it's unopposed, make sure that there was service of the order, and make sure that everything that are set out in the papers qualifies or justifies the granting of the final order.
Okay. Why does it matter whether it's opposed or not as to what the requirements are?
If you've granted a rule 9 and it is opposed, you would have to hear on the return date the opposing parties' objections or the case that they lay before you in opposition of the granting of the interdict or the order that was granted, the rule 9. Consider all the papers, apply audi alteram partem rule applies. You need to consider both sides and make a finding as to whether the rule 9 should stand, should be granted, or should be discharged on the papers.
When you are sitting on appeal, and you are asked to overturn factual findings made by the trial court. Under what circumstances would you interfere with the factual findings of the trial court?
If the misdirection by the trial court is of a serious nature and not based on credibility findings or impressions by witnesses, and you find that the misdirection by the trial court is legally vitiated, or it's simply on the probabilities not correct, you may rectify that on appeal. But obviously the test is that the appeal court should be slow to interfere with the findings of the trial court.
And if you are sitting on appeal, and what's on appeal is a decision taken by the lower court in the exercise of a discretion, under what circumstances would you interfere with the order or decision?
Are we talking about a criminal matter or a civil matter, CJ?
Let us say a civil matter.
Civil matter. CJ, can you just ask me the question again?
If you are sitting on appeal, and what is on appeal is a decision made by a lower court in the exercise of a discretion, under what circumstances would you interfere with the exercise of that discretion by that court in making that decision?
I don't think that you would easily interfere with the discretion of the trial court. But if there are material misdirection and an error in law or misdirection on the facts before you on the papers, you would have to deal with that issue in the appeal judgment.
Yes, thank you. I will now allow the acting judge president to put questions to you, and thereafter I will allow the representative of the Premier of the Free State, MEC Kabate, to do so, and thereafter commissioners, and they will do so to try and see how your appointment would meet the selection criteria which this commission has agreed upon, and those include whether you are a person of integrity, whether you have the necessary energy and motivation, and whether you are a competent person, technically competent, and whether you have capacity to give expression to the values of the Constitution, and whether you are experienced in regard to the values and needs of the community, and whether you have an appropriate potential, and what message your appointment would give to the community at large, and whether you are appropriately qualified, and whether you are a fit and proper person, and whether your appointment would help reflect the racial and gender composition of South Africa.
Thank you, CJ.
Okay. Acting JP, please go ahead.
Thank you, CJ. Good morning, Ms. Page.
Good morning, Acting JP.
In the 21 weeks that you've acted in the Free State, how many times did you do motion court, unopposed motion?
Unopposed motions was only once in the second term. There were about 90 matters on the roll that day.
Okay. During the period of, during the 21 weeks that you've acted, did you do any civil trials?
I'm sorry, AJP, please speak closer to the mic so we can hear you.
Did you do any civil trials during that period?
I did. If I have to count, I think there was one road accident fund trial, about 2 of them that I actually did the trial, heard the trial, and gave judgment. There was also another matter. Kumalo was Minister of Police. It was a trial that I heard and gave judgment on. That's coming to mind. So yes, I have done trials as well. Thank you, Acting JP.
Thank you. At the time of completing your questionnaire, you had 4 judgments outstanding. Have those judgments been delivered? Were
That's
they delivered
correct.
within 3 months?
They have. Thank you, Acting JP. They have. All my reserved judgments were delivered within the 3-month period.
Thank you, Ms. Page. Thank you, CJ.
Thank you, AJP. Excuse me. MEC Kabata, do you have some questions for the candidate?
Yes, Judge President, I do have some questions for.
Please go ahead.
For the candidate. Thank you very much. There will be 2 questions. The first question will be to Mrs. Page Dumela.
Good morning, Commissioner.
How are you?
I'm a little bit nervous, but I'm
that you see. The question that I want to ask is, I can see that in your CV, you worked at family courts and the children's courts.
That's correct.
Now, why is it that such cases will be not necessarily the ones that you were dealing with? I'm dealing with the cases in general that are still being at family courts, and such cases will be postponed many times and be dragged to take long. Does the judiciary comprehend the emotional trauma and the financial strain on the victims and the witnesses? Remember that the first trauma is when they are violated. The second trauma is a delayed justice. What plans and strategies will you put in place to end this challenge if you could be considered?
If a matter is placed before me, then I deal with it expeditiously and grant and deliver my judgment also expeditiously. Ensure that if it is, I'm just going to speak wide-ranging, if it's a criminal matter where the victims are I think you refer to family law matters, so children's court matters and family law matters. So let me just rephrase. I deal with them always expeditiously, taking into account that there is trauma and there is a need to deliver a better service and to prevent further trauma to the victims. So the moment that the matter is before me, I would not simply postpone a matter, but rather either stand it down if there are things that can be sorted out. Sometimes there is trauma, people can't always, the witness is not able to testify now because of the condition she's in and the nature of the matter and so forth. But I would not postpone it for months or weeks even. I have, in fact, always had the practice in any court where I sat that I finalize my matters expeditiously and that I deliver judgments as soon as possible. When I left the court as a magistrate, I, in fact, had no reserved judgments. I always ensured that I deliver and finalize my partly heard matters. So I would give attention to that if I hear any matters related to family law, children, court matters, etc., and in general, all other matters that are placed before me, Commissioner. I hope I answer the question.
Thank you very much. Though I was not necessarily looking at you as a person, I was looking at you going to work within a collective and having to ensure that the judiciary in general improves its services. My second question will be on children in conflict with the law. And let me put it to you that we have met with the parents of children who are in conflict with the law, because we are having 3 secure centers that are under social development in the Free State. Now, there is a complaint that racism is at play in terms of these cases. The Black parents are complaining that when they request for children to be put under their care, it is never granted. But there are no white children who are being referred to either correctional service supervision nor secure center services supervision. They are released to the care of their parents. Whereas with Black kids, it is never granted. They are referred to either correctional service supervision or the secure center services for children in conflict with the law. So my question would be, are you aware of these complaints, or are you know of the fact that it indeed happens like that? And if you know, and you become a successful candidate, how will you change the situation?
I think to answer the question related to the racism, one of the values of our Constitution is that we are a non-racial, non-sexist democracy, and our judiciary is subject to the supreme law, which is the Constitution, which requires that there be no discrimination based on race. I have, in my years in the district court, dealt with child justice, the child justice court where I sat. I've also done the preliminary inquiries, and I cannot say that I've come across it personally, that would be the trend, but obviously that if it is so, I would frown upon it, and if the matter should be before me, I will ensure that that situation is rectified. I think there are processes in place. If the matter is sent on review, obviously it'll have to come back from the district court for a judge to deal with that, but I do not stand for that. Children, especially in conflict with the law, that they be discriminated against based on their race, as to where they are being detained or released. The principles should be applied equally to all the children who are in conflict with the law. The Child Justice Act has very strong measures in place for protection of children in conflict with the law, related to arrests, related to how they end up in court. The preliminary inquiries are there for that specific reason, so that a magistrate can establish as to whether this matter could be mediated, and whether it should in fact be referred to a children's court, or whether it could be kept out of court. And these measures need to be applied by the police. Children not supposed to be arrested, transported in police vans. There are so much. I'm sure that there are still instances where that doesn't happen, but if it should come to my attention and I'm able to deal with the matter from the level where I'm at, I would obviously rectify this and on review or appeal, if that is possible, and if it is in that forum that it comes before me. But as I say, that is unfit. There should not be any discrimination on any level of that kind. I hope I answered the question, Commissioner.
Thank you very much, Ms. Page. Thank you very much, Chief Justice.
Thank you, MEC. Commissioner Moiman.
Thank you, Chief Justice. Good morning, Ms. Page.
Good morning, Commissioner.
Just one area that I want to bring to you. The fact that other bodies like LSSA and also NADEL, they don't support your candidature because one of the areas that they raise is that your experience is mainly in criminal and family law.
I'm sorry, Commissioner, I'm not sure whether everybody can hear you well. Maybe bring your mic closer.
Thank you, Chief Justice. Ms. Page, I was saying that what is your view with regard to the point raised by the LSSA and also NADEL about not supporting your candidature because they say your experience is a bit limited as it is mainly in criminal and family law?
With respect, I would disagree with that comment since I have extensive experience in civil court, both in lower courts as well. Okay, I only have 22 weeks as an acting judge. I have dealt mostly with civil matters and with respect to everyone and with humility, I will submit that it was quite easy for me to adjudicate civil matters of different levels of complexity in a satisfactory and potentially, I'm sure that I will be able to improve should I be appointed. My limited acting experience should also not be seen as on its own, but be seen in the broader picture. I have 17 years of adjudicating experience as a magistrate, where I have dealt with many civil matters covering many areas of the law. I'm fit and proper and capable, competent to adjudicate civil matters of complexity and less complex matters expeditiously and with competence. And I do not agree with the comment that based on a lack of experience in civil law, I should not be appointed. Thank you, Commissioner.
Thank you. The reason why I brought that those comments to your attention is because I went through one of your judgment on page 27, the Rahida and Taukubo.
Freddie King Takubong.
Yes. Can you just, as part and parcel of contesting that assertion from NADEL and SSA, just deal with the aspect of that matter?
Thank you, Commissioner. Did you say what page was that? I am still paging. 26?
27.
27. In this matter, it's like I indicated before, it was my first case when I started acting on a Monday morning with two senior judges, and I had to hear this full bench appeal matter. if you look at the judgment, I've had to delve into legislation that I probably previously haven't dealt with, and had to really delve into it and do research in the matter, in the legislation. The papers were about more than 800 pages. I stood up, I accepted the challenge to write this judgment, and I feel that this judgment is an illustration that I am competent and capable of dealing with matters, civil matters. This is a full bench appeal judgment that I've written. If you want me to, I could quickly refer to parts of the judgment which illustrates my competence. I've brought it into the contrast with the Constitution. I don't know if I should go into the facts, Commissioner, of the case more, or am I going to accept that the facts are before the commissioners?
You are the candidate. You must say yourself, because LSSA and Adele says you are not experienced in other fields like mining law.
All right. Thank you, Commissioner, for the guidance. So in this case, it entailed the appellant, who is Rahida Investments, who bought a farm which was rich in iron ore and manganese, as per my judgment. And in this year of purchase, the farm was sold to his son. So there were some circumstances on the factual issues here that I don't want to maybe expand upon, but it required of me to look at legislation such as the MPRDA, the Mineral and Petroleum Resources Development Act, the BBBEE legislation, and Mining Charter. I found that these portions of the legislation was fundamental to, or granted fundamental context to the interpretation of a shareholders agreement, which was entered into between the BBBEE partner, who is the first respondent in the matter, and I had to delve into this legislation, which was not a field I was aware of or very au fait with at the time. It required the application. Was for an interdict against the first respondent to prevent him from acting on behalf of the applicant in the matter, Rahida Investments, since his shares had been removed by the applicant. He was also removed as a director later, and the applicant wished to interdict Mr. Takubong, the first respondent, from acting on behalf of the company Rahida Investments. So, in order to deal with whether the opposition to the application was that the applicant did not have the locus standi to bring the application, and in order for me to make the decision, the central issue in that appeal was whether the motion proceedings launched with the court of quo were properly authorized, and to establish the authority and locus standi of the appellant. It was then necessary for me to determine whether the removal of the first respondent was duly effected in terms of the shareholders' agreement, the 2016 shareholders' agreement, since there were two of the shareholders' agreements.
Thank you, Ms. Page.
Thank you.
I'm happy now.
Thank you.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Klaba.
Thank you very much, and good morning, Ms. Page.
Good morning, Commissioner.
Thank you very much.
We have gone beyond 30 minutes, I just mentioned that.
Thank you very much, SJ. I just want to go back to the date when she obtained her first degree, BA. I'm doing that because initially she said she started it in 1986.
Yes, I thought I heard so too.
Yes, and then later said 87, but finished in. So I just want to have clarity on that aspect.
All right.
Okay, so you started in 1987 to 1989.
Yes.
And then you went back to do in 1990. In 1990, you went back to do that one outstanding course.
But I also I did it together with my first year LLB. So
Correct.
I sort of carried over that one subject. I think, I'm not sure, it's so long ago, Commissioner, but it was probably Roman law. I can't remember,
Okay.
but I did carry one BA law subject over into my first year LLB.
All right. Which then meant that you completed your BA in 1990.
Yes, that's correct.
Is that correct?
That's correct.
All right. I just want to get back to your application.
Yes.
All right? And your application says you acquired your BA law in 1991.
That is the date that is on my certificate on which the degree was
So
conferred.
when you completed your BA,
The BA law.
your BA law,
The certificate or the graduation
no,
date.
leave aside the
Yes.
certificate. When did you complete? When you completed? When did you complete your BA law?
In 1990.
In 1990. So you agree with me that your entry here in your application is incorrect.
It's incorrect because I took the date on which my certificate's date is in 1991,
Okay.
when it's the day on which they
No,
bestow
it's
it.
fine. No, it's fine. It's fine.
Thank you so much.
Then
Commissioner.
I look at your CV.
Yes.
In the CV attached to the application says you acquired your BA law in 1992. Can you see that?
I see that. That's also that must be 1991 when I.
So the entry here is also incorrect.
Yes, it's incorrect.
Is it fair to say that you don't pay attention to detail?
Just based on that one aspect, Commissioner, I would say no, it's not completely correct. I made an honest bona fide mistake when I entered that date on there, but I've attached my certificates to the application.
No, it's fine. No, it's fine.
Thank you.
How long did it take you to complete your articles of clerkship? I'm sorry, CJ.
Yeah, no, that's fine.
Thank you. I started in February 1997 that I moved between firms. At the time, as you know, it's very difficult with being a woman and in private practice. I had then been a prosecutor and started my articleship.
No, I'm asking how long did it take you to complete your articles of clerkship?
I started in 1997 and I was admitted as an attorney in 2001.
So how long did it take you to
4
complete?
years.
4 years. And in the period of 4 years, you moved from Van Wyk. I'm talking about the
Yes.
articles.
Yes.
You're doing articles of
Yes.
clerkship. From Van Wyk and Forchi to where you stayed for 6 months.
Yes.
And then to Mohammed and Associate, where you stayed for 5 months.
Yes, that's right.
And then to G. Duncan and Associate, where you stayed for 5 months.
Yes.
And then to Jean Stale and Attorneys, where you stayed, but you don't mention the period. For how long then?
Oh, I stayed there until I obtained until I was admitted as an attorney, and then beyond that, I was appointed up to 2002 when I was appointed as a magistrate. In other words, I was appointed as magistrate from my last firm, Gerrie Stale and Attorneys.
Okay, thank you very much. My very last question, CJ, with your permission. You finished us with your certificate of good standing for 2020, and you undertook to finish us with an updated certificate as soon as you received it.
I have.
Have you finally obtained your certificate, your updated certificate?
I have, and I have furnished it via email about probably 2 weeks before I came to the interview. So it should form part of my bundle, yes.
Thank you very much. Thank you very much, CJ.
Thank you. I thought I may have not heard correctly, but Commissioner Klaba has confirmed that I had correctly. What happened when you said you started your BA in 1986?
Oh, I did say 87.
I don't think I can forget my first year at university.
No, I did say 87, CJ. I did say 87. I think maybe I spoke a little bit too soft.
Okay, all right. Commissioner Singh?
Thank you very much, Chief Justice, and good morning,
Morning,
Advocate.
Commissioner.
Just one question. I might have missed this in your submissions. I'm just trying to understand your career path.
Yeah.
From being a magistrate, you seem to have left or resigned or whatever, and then you formed your own firm of attorneys. And if you could just tell us where that your firm of attorneys was formed, and then arising from that, how come is it that you were given an opportunity to act in the Free State Division? What led to that happening? Thank you.
I've been on the bench for 17 years in the district court and the regional court, acted quite a few stints. I also applied for regional court positions. I was unsuccessful at the time, probably due to demographics in the Western Cape. It was not always possible. And after 17 years on the district court bench, I mean, I had to consider many things. Sometimes in your career path, you decide to step out of your comfort zone and enter into a different phase of your career so as to empower yourself more. I was very happy as a magistrate. That was where I thought I would be and retire, but you need growth and development and you need to listen to that voice inside of you. So there were many factors that I've considered, and when I took that leap of faith and started my own practice for my own account in Cape Town, Goodwood, Monte Vista, it was a very liberating experience for me because now I could expand my field of application of the law more holistically. I had the opportunity to again appear in the High Court in matters, and it was a personal growth development dream, and just simply based on the voice inside of me to always live and not just stagnate in one space. It was a surprise to me when I received a call from the Judge President from the Free State. I think through our association, International Association of Women Judges, my CV had been floating for acting, and unfortunately I did not get that opportunity. And I think it should have been through that means that I received an opportunity in the Free State, which I appreciate has come my way, because to be appointed to a judge is my ultimate goal. And if I had to take a leap of faith and step out of my comfort zone to make myself more available or more to grow myself more on different levels, I think then that probably paid off. And I, like I say, it's all dependent on, you get invited, you don't know. I was very happy and elated when I received that call, since it has been a dream of mine for long to enter or to rise to to the High Court bench.
No, thank you very much.
Thank you.
All I can say is keep the faith. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner. Commissioner Matolo-Lepu.
Thank you, Chief Justice, and good morning, Ms. Page.
Morning, Commissioner.
No, I think my question it was asked by Commissioner Kaba, but one of the things that worried me is that as a candidate attorney, you went through 3 firms of attorneys, and I was just trying to figure out, did you seed your articles that often, or what was the reason why?
Purpose.
Because you'll want to hold on to a firm to finish your articles. Was there a problem?
Commissioner, I think, it's like I just answered, you navigate your career as a young woman in the profession, facing many, many obstacles, and I don't know if I'm still audible, yeah. But when I started, I actually left prosecution. I was prosecuting and I had experience, so I took a dip in my salary and then decided I needed to complete my articles, which was something I felt that if I completed my law degree, I wanted to do. And so when I started my articles at the firm in Paarl with Van Wyk and Forshey attorneys, I was there for 6 months. It was quite a good experience in that, but also life happens at times, and I went through a personal issue at the time, so I could not stay on at the firm. And then once I was in a better space in my life, personal life, I then sought articles again and was appointed at H. Mohammed and Associates as articles. It was difficult in the sense that you, as a woman, you sometimes are facing obstacles being a woman, but at some point I was unable to stand for that I was experiencing at that firm, and I decided not even to cede my 6 months of articles and rather sought articles with somebody else. I was with Duncan and Associates, and from there, my articles was ceded to Gerrie Stale, where I then stayed and completed my articleship, and I was then admitted as an attorney. So just in brief summary, it's there was a year of it that I did not cede, which I could have done, but elected not to do at the time, for no sinister reason. It just was better for me to do so, and at the time. And I hope I'm answering the question, and if I laid any fears, if there are any in that regard, I would gladly answer any fears that you still may have.
No, thank you. I think my concern is, candidate attorneys, we need to take care of them. So for me, that's why I was more worried. Why you just jumped from one firm to the other? Maybe there was a serious issue.
As I've said, I've had my challenges, and might I also just add that that might be part of the reason why during my period as a legal professional, decided to mentor female students, to reach out a hand to them and to assist them to enter into the profession better equipped, and to know what the challenges are that they might face at some point, and to push through and to stay in the profession and face your challenges head on, which is what I've done, and all on my own. So I hope that answers the question.
Just to say that when we mentor those attorneys now, please don't let them die inside. There's an LPC to report such issues so that we assist you.
Thank you.
Second question is just a comment. The MEC asked you greeted you in Sotho, but you decided to answer in English. So I wanted to find out, do you have a problem or maybe just...
I don't have a problem, but I was a bit uncertain how to greet in the Sotho language.
Oh, okay.
But not for any reason. Now, obviously, I embrace all our languages and our rich cultures. And I'm prepared to, I mean, when I move to Bloemfontein, to connect with that side of my role as a judicial officer.
Thank you,
Thank
Chief
you.
Justice. Thank you.
Thank you, Commissioner. Commissioner Baloyi.
Thank you, CJ. Good morning, Ms. Page.
Good morning.
Yes. Ms. Page, the issue of experience has been raised with you, and you were told the bodies that do not support your candidature because they say you require more experience, and in certain areas. Now, it seems to me that one of the good qualities of coming into a new environment, or character qualities, is for one to accept their shortcomings, because then you are awake and aware of it, and you will go out to seek advice, counsel, and guidance. So your starting point has to be that you acknowledge and concede that I do lack experiences in certain parts. Is that a fair proposition to make?
That's a fair proposition to make.
Okay. Now, if you look at your form, your questionnaire, you list in paragraph 1, and that is at page 9 of the question, paginated 9. And paragraph 1 asks you to please outline your entire career in the law, giving an indication of your principal areas of legal interest and involvement. This is the time that you are completing this form. And you say prosecuting in municipal and criminal courts for 4.5 years, criminal and civil litigation as candidate and attorney for 5.5 years, magistrate in both criminal and in both criminal and civil courts for 17 years, including stints as magistrate. And then you say regional courts, family court, domestic violence courts, and children's courts. That's how you've captured your entire career in that paragraph 1, right?
Yes.
Okay. And then you go again to paragraph 625 of the same questionnaire. And this is you describing your own experience. You say criminal law 50%, which is the highest percentage that you give. The others are 0, and then you get to 625, and you say contractual 10%, and you don't give details of what is contractual, because there's so much of it.
That's right.
And then you say delictual 10%. Again, you don't give any particulars. And then we are back with family law and other civil work. So your own description, you've given your description. So when a comment is made that other than these areas, you do not have the necessary experience, that is a fair comment, right?
Yes, I would think so.
Yes. And I don't raise this in any way of criticizing, but it is to acknowledge that your journey, the journey that you have taken, it is such that for the High Court, you have many areas of learning and growth that you still have to do.
Yes, I would agree with you that that is the case, that I have only had 2 stints in the High Court.
Yes.
And yeah, so...
Okay.
Well, I'm sorry, I just want to make sure I understand. Did you say you agree with the proposition put to you by the Commissioner that there are still many areas of law where you need to grow?
CJ, the work that I have encountered in the lower courts, I've also encountered in the High Court similar matters. And obviously, should I be appointed on the High Court bench and be faced with matters which I haven't dealt with before, be that maybe more administrative matters, administrative reviews, and so forth, then yes, I would obviously be able to prepare myself and to be in a position to...
Hang on, Ms.
Sorry,
Page.
I am going off the point.
Hang on. Listen, please.
Okay.
Listen. Commissioner Baloyi put a question to you. You responded, but I did not hear what you were saying. So I've put the question to you again so that I understand what your answer was to her. So I put the question again. Did you agree with Commissioner Baloyi's proposition that there are still a number of areas of law in which you still need to grow? I hope I've captured the question correctly.
You have.
Yes. Did you agree with her? Did you not agree when you responded?
I acknowledge that you always have to learn. It's a journey of learning forever. I feel that I am competent and have sufficient experience in civil and criminal, family law, and other matters, sufficient so to be appointed to the bench, on the High Court bench.
Does that mean you disagree with the proposition she
Yes,
put?
I do disagree to an extent.
Sorry?
I do disagree to the extent that I acknowledge that judicial education is, for any jurist, you're still learning every day. But I would say that for me to be appointed, judged on my experience so far over the 28 years in the profession, that be taken into account holistically, and that I am confident in saying that I am sufficiently experienced and competent to be appointed to the High Court bench.
But when you responded to her, did you disagree at that time before I intervened, or did you agree?
I agreed that it would be a proposition in general, but I wasn't sure if she is putting it straight to me to say that that is applicable to me specifically.
Oh, but she was asking you. You are the candidate.
I think I might have not really seen the question in that way, so I disagree with her.
You see, Ms. Page, one of the things that is quite important for anybody who wants to be a judge, as is reflected in the selection criteria that I read out earlier, is integrity. If you are asked a question, it's important to answer it with integrity and honestly, even if it's against you. You understand?
Yes.
In other words, a candidate shouldn't want to be a judge by all means, to the extent of not giving honest answers to questions that are put to her. You understand that?
I understand that,
So
CJ.
why I wanted clarification was because I understood you not to be disagreeing with her when you responded. And yet there is an answer that you had given earlier on which made me expect you to disagree with her. So that's why I sought clarification. You understand?
I understand. Thank you, CJ.
Okay, all right. You were not done.
I wasn't. Thank you, CJ. Well, I think, Ms. Page, I'm going to put something to you from one of your judgments,
Yes.
still in my theme of seeking to get you to accept that you have room for growth. You still have to grow, and you
Yes.
may not necessarily be ready for appointment at this stage. But let me preface it
Yes.
by saying that I think I accept that the number of years that you have spent in the magistracy is not in itself a qualifier for you
Yes.
to be recommended for appointment, right? It's not what makes you.
No,
Yes.
I agree with that.
Okay. Now, if you could just look at your judgment, and this is in the matter of Buckhazen, NO, it starts at page 51, paginated. 51, Buckhazens, a number of them against First Rand. And this was a simple, it was a simple application of condonation and lifting of the bar.
That's right.
You remember this matter?
I do.
Okay. All right. So this invokes the rules, not even questions of law at this point. Now, you say at paragraph 4, and I'll make a proposition to you at the end. At paragraph 4, you're dealing with condonation. You say, during argument, this is the last sentence. Paragraph 4 is at page 52. You say, during argument, this is considered by the respondent, and it is not necessary to deal with condonation, with the condonation aspect. Maybe for context, let me read the whole paragraph. It's a short paragraph. It says, the application for condonation and upliftment of bar is supported by an affidavit by Jan Andries van Aswagen. The reasons for the delay in delivering the plea are attributed mostly to the complications caused by the COVID-19. And then you say, during argument, this is considered by the respondent, comma, and it is not necessary to deal with the condonation aspect, right? Mm-hmm. And yet, in all the following paragraphs, you deal with condonation. You deal with factors that are relevant for condonation to be considered. And here's how you then conclude this. You go to paragraph 24, which you find, paragraph 24, no, there's no paragraph 24, Chair, I've lost my references. Well, maybe I can still make my simple point. So the rest of the body, you're dealing with condonation, the requirements for condonation, and then you say, in paragraph 10, I am satisfied that good cause has been shown by the applicants, okay? And the application for the removal of the bar may succeed. You say that. Now, nowhere in the body do you say, I grant condonation. You just discuss the requirements, even though you started off by saying it's not necessary. And then in paragraph 10, you say, I'm satisfied good cause has been shown by the applicants and the application for the removal of the bar may succeed. I'm not going to deal with that. And then your order is the application is granted, and that's all you say.
All right.
Right? The point I'm making to you is there is so much defect in the body of this judgment, and I can only attribute it to lack of experience and growth, that with time, the kind of errors that are in this judgment would not have occurred with time. Are you prepared to make that concession at least?
May I respond to your summary of the judgment, First Commissioner?
Yes.
So this was an application brought by the applicant to uplift the notice of bar, and part of the affidavit deals with the reasons for the delay in delivering the plea. When I mention the fact that during argument it was conceded, what I meant there is the concession was made that it was in agreement, the parties were in agreement that the delay in delivering the plea within the prescribed period was due to COVID-19 complications, and it was that fact that was that the respondents have conceded, that as a result of COVID, the reasons of COVID, or COVID being the state at the time, that was the reasons furnished for the delay which the respondents experienced. And if one has the application before you, which I probably did not find at the time to deal with, it was those specific reasons given, the courts were closed, etc. So it was that fact that was conceded by the respondents, that both parties have conceded. And then when I deal with the requirements of the upliftment of the notice of bar, I deal with further in the judgment with the way and the manner in which the matter then proceeded. That the plea was then finalized on the 5th day before being ipso facto barred. It was then emailed to the respondents, and the attempts made for them to serve the plea on the respondents, etc. So those reasons were granted not for condemnation, but for the reasons that were given in the application as for the upliftment of the bar, which I then found that the explanation for the delay was bona fide and not made with the object of delaying. So what I'm trying to say is that the notice of bar, the upliftment of the notice of bar is a specific procedure that needs to be, or an application needs to be brought, and the court needs to evaluate on the papers.
Ms. Page, can I please
Yes.
can I please interrupt you?
Yes.
The point that I'm making to you is, do you concede that in this judgment, what you do is you set out the law as it relates to condonation? That's what you do. And yet you started off by saying that it's not necessary to deal with condonation. You then go on to discuss condonation, and then you conclude, just before you make the order, you then say, I'm satisfied that good cause has been shown by the applicants, and the application for the removal of the bar may succeed, which is completely incomprehensible what it is that you're doing there. And then you say, I make the following order, the application is granted. And I'm not criticizing you about this judgment. I'm merely making the proposition to you that the errors in this judgment, right, how you get to your order, this order, the errors in it are further evidence that you would benefit from either further training, which may come with you serving on the bench as an acting judge, or mentoring. If you were to be appointed, you are one candidate that, in my opinion, seems would require mentoring. That somebody looks at your work and guides you. You are not ready to sit on your own right judgments and distribute them if this is an example, if this is used as an example.
Thank you. May I respond? The condemnation is not the application that was before me. It was an application for the upliftment of the bar, which required different considerations.
Sorry, Ms. Page.
Okay.
Shouldn't all of that be clear from your judgment?
All right.
Should you have to be explaining that? Shouldn't that be clear in the judgment?
I would accept that. Obviously, anyone and myself too, I'm always open to be taught and to be guided and to be mentored as mentioned by the Commissioner. I accept that.
Yes.
CJ, thank you. Perhaps just to make a last statement, not a question. The first sentence in that judgment says this is an application for condonation and lifting of the bar. Thank you, CJ.
Thank you, Commissioner Baloyi. We have taken quite some time with this candidate, but Commissioner Pillay did raise her hand. Other than her, I propose to look at the commissioners who are attending virtually. I'm not aware that there is another hand. Yeah.
Thank you, CJ. I was going to ask questions, but I think I'll just confine myself to making just one comment, Ms. Page, and that's when I was looking through your judgments. It struck me that the bulk of your judgments were in matters where you sat as one of a number of other judges, either as a full bench or as a two-person bench.
Yes.
And that you had selected judgments in matters where you sat on your own, which were really either interlocutory matters, and I think there's really just one full substantive judgment. That's in the unlawful arrest and detention matter. So speaking for myself, I struggle to get a good sense of your judicial philosophy and your reasoning. And I really was looking for that, to be honest, because I would have liked to favor you as a candidate. I struggled to find that because I was hamstrung by your choice of judgments that you had included in the bundle. So I just want to make that comment, and you can deal with that. Right.
Do you want to say anything? You might not have anything to say. It's up to you.
With the choice of the judgments that I forwarded, there were other judgments as well, which I wrote later on and had to submit for delivery after I'd already sent the judgments in. So also from district court judgments I've sent later when I saw the comments. But I accept, yes, the comments are fair.
Yes. Okay, commissioners attending virtually. Is there anyone who has a question for the candidate?
Yes, Chief Justice.
Yes, Commissioner Barnett.
Yes. Ms. Page, if I may ask, just to refer you to the judgment of State versus Molefe, where there's an automatic review. And once again, it was you and I think Judge Danisa that where you set aside a conviction and sentence regarding a housebreaking and theft. There are two encouraging paragraphs on page 75 and 76 of the bundle where you refer to a judicial officer's duties in terms of section 35(3) of the Constitution, and you quote from the Ramalifa state judgment of the SCA. I just want to ask you, and eventually this was set aside, this judgment in the magistrate's court. My question to you is this: what is your attitude or approach towards descending into the arena?
I do not agree with that. Whenever how I adjudicate all my matters is to give the parties the opportunity to place their case before me, to give strict compliance with Audi Alteram. I do not enter into the arena only for questions of clarity and to maintain the decorum of the court. I would proceed to say something to a witness, a party. I strongly frown against in our democratic state today with the judiciary. That should not be allowed in, or should not have been a problem any longer. And with specific reference to this case, seeding into the arena was really very serious and flagrant breach of the right to a fair trial of the accused person at the time. He wasn't allowed an opportunity to even cross-examine the manner in which that the witness was addressed by the presiding official. It is something in a court where I sit, I am always respectful, dignified, and I appreciate that litigants come before the court when accused, expecting a fair trial, and this is a clear example of how it should not be done in any court. I hope I answered the question.
Thank you.
Thank you, Commissioner Barnett. Any other commissioner attending virtually who has a question?
No, thank you, Chief Justice.
Thank you, Commissioner Breitenbach.
None from my side.
Thank you, Commissioner Shabangu Mdawe. We have come to the end of your interview, Ms. Page. I take this opportunity again to thank you for availing yourself to be considered for appointment. I'll give you 3 minutes if you have any 2 or 3 points that you want to emphasize to the commissioners to especially bear in mind when they consider your candidature But if you feel that all issues have been adequately dealt with, that would be fine as well.
Thank you. I just want to thank everybody for the opportunity and for the nomination from the International Association of Women Judges. It was an honor for me to have been here and to come so far. So I thank you all very much.
Thank you very much. You are now excused.
Thank you.